Welcome and welcome back to What Just Happened, Surviving the Family Court, our ongoing podcast series dedicated to getting you, the listener, or your loved ones and friends over, past, and through the toxic swamp that is or can be the family court here in Rhode Island and in the Commonwealth of Massachusetts. I am Timothy Sweet. I am a Rhode Island family court attorney. I am joined here on this podcast by my bucket of deplorables. I've got Tony Jones of Tony Jones Omnimedia doing this stuff behind the scenes I don't understand. Guillermo Garcia of Pixels Digital Marketing behind the camera, and this is all created and coached and marketed and produced by Patricia Raskin of Raskin Resources Productions, who, for better or worse, is responsible for this. And then we're getting into episode 8 now. And what I'm going to talk about today is something I wanted to talk about for a while, and that's what we're calling it, is exactly what to do when you are on the stand, your testimony is being taken, and you have to survive cross-examination. And cross-examination is when the other party's attorney gets to ask you questions, the attorney who is hostile to you, and how to conduct yourself through that and how to kind of wade through those waters and, as always, get off to the other side in one piece. Because what I've noticed in the practice more and more nowadays is that everybody wants a hearing. Fewer and fewer people want to negotiate, bicker, barter, and steal. They don't want to compromise. They want a hearing. They want the judge to hear their side of everything. And while everyone wants a hearing, nobody wants a decision, which is what a judge is going to give you after hearing all the testimony. Here's a tip that judges know and that lawyers learn. It's actually stunningly difficult to get somebody to admit to something on cross-examination that they don't want to admit to. And it's actually really very difficult. And so this episode 8, is going to be about you don't help them. Don't help that attorney and their surprisingly difficult task getting you to admit to things that you have no right admitting to. The opposing counsel doesn't need your help, and you're not going to spend any of your time helping them because you've listened to episode 8 of this podcast. And while the parties want hearings, lawyers actually hate hearings. I know I hate hearings, and it's because the stress of a testimonial hearing, an evidentiary hearing, can really get to people. And I've seen it time and time again where the strongest case can fall to pieces because a critical witness is just undone by the limelight. The pressure and the stress of every word you say being taken down by a stenographer and being scrutinized by a judge, and the objections and arguments of the opposing counsel, and just being overwhelmed by everything that is at stake in that moment while you're on that stand giving your testimony. I have seen people forget how many children they have. I have seen people completely blank on the birthdays of their children. I've seen people mix up years and genders and dates. Some people get so nervous on the stand that they actually get physically ill. There are times in a trial or in a hearing where the limelight is just too much for a witness, and for whatever reason, the moment becomes too big for them. And once that happens, sometimes a lawyer has truly no idea what to expect from that particular witness. I myself spent an entire weekend going over testimony with a client who I was going to put on the stand, did put on the stand the following Monday. Spent the whole weekend on this. Not terribly complex stuff. And he got up there on the stand, and within 15 to 20 minutes, he completely froze. The moment became too big for him. The stress got to him. What's at stake got to him. He completely froze up on the stand. Just days after going over all the testimony in the relative comfort and safety of my office. Testifying can be a real bear for people who are not accustomed to that kind of scrutiny. And so there are 3 things to count on, 3 things that you can rely upon, no matter how difficult the subject matter of the testimony, no matter how difficult the opposing counsel is being to you or being in general, no matter how ornery your judge is. There are 3 things that you can count on in giving your testimony that'll get you through the day and will help you with your case. Number 1, you're only to answer the question that is asked. You only ever answer the exact question that is asked of you. Don't go off on tangents. Don't tell stories. Don't give a narrative. Don't couch why you did what you did or did not do what you did not do. You only answer the question that is asked, and then you wait for the next question. No running off at the mouth. There's nothing other lawyers like more than when someone on the witness stand starts telling stories. You only answer the question asked. That's thing number one. Thing number two, cross-examination and giving testimony is not a quiz. You are not, just because a question is asked of you does not necessarily mean that you should know the answer or you have to know the answer. It's not a test. If you don't know the answer to a question you are asked, I don't know is a really great answer. You just say that, I don't know. The answer I don't know to a question and a cross-examination can really leave the questioning attorney powerless. What so many people do wrong is that they try to answer questions they have no right answering. If you don't know the answer, don't try to make up an answer. If you don't know, then you don't know, and you're going to say, I don't know, and leave everything else up to the attorneys. There's nothing you can do. There's no surer way to lose credibility with the judge than to try to answer a question that you have no information on. So number one, you're only going to answer the question that you are asked. Number two, you are not going to treat this like a quiz or a test. If you don't know the answer, you're going to say, I don't know. And number three, the easiest one, and the one that gets the most people, just tell the truth. Just tell the truth. Most judges practice in either the family court or another court for several decades before they apply for a judgeship. And then before you waltzed into their courtroom and took their stand, they have been judges for a long, long time. Nobody on God's green earth can tell if you're lying quicker than a judge. Just tell the truth. If you've taken your case this far, then you believe in yourself and you believe in your case, and on the stand is where you should show how much you believe in it. Tell the truth. Only answer the question that's asked, and don't tell any stories. And you are going to find that you're just fine, and you're going to get through the most brutal cross-examination. And again, you're going to get to the other part of that swamp. You're going to get to the other side of that bridge. You're going to leave the courtroom with your head held high, and you are going to be just fine in the long run. Those are the three things to do, the three simplest things to do to get you through the most stressful trial situation of cross-examination. They work every single time as long as you remember them and you follow them. This is Timothy Sweet, Sweet Family Law. I'm a family law attorney in Providence, Rhode Island. I'm located at 10 Elm Grove Ave, ELMGROVE, Providence, Rhode Island, 02906. You can find me on Google. You can find my website, www.timothymsweetlaw.com. You can also email me, timothymsweet@gmail.com, and you can find me on almost any social media platform, and you can listen to this podcast almost anywhere one can listen to podcasts, and you can now find me on YouTube as well. Thanks again to Pixels for that. Next week, I think what we're going to do is we are going to discuss the terrible issue of legal fees. We're going to, as all things with this, we're going to try to take something that is difficult and stressful, and we're going to strip it naked and expose it, and hopefully break it down and make it more palatable and less stressful, and make it less of a boogeyman than it has to be. I am sick to death of my own voice at this point, and so what I'd like to do is, as I do every week, I'd like to ask for feedback from the listener. What we're looking for here at What Just Happened is any kind of question, concern, anomaly in a family court case you had, anything you can bring to our attention that you would like to be addressed and brought to the light of day. That'd be very helpful. You can find me on Facebook, or you can email me for that. Thank you so much for listening to episode 8. I hope that you never have an occasion where you would need this episode, but if you do, if you're ever in a place where you have to take the stand, this short speech will get you through it just fine. Thank you so much. We will see you in 1 week to discuss legal fees. Timothy M. Sweet, Sweet Family Law, What Just Happened, How to Survive the Family Court. Thank you.